Gentlelady from Pennsylvania, Ms. Wild.
Thank you, Mr. Chairman. Ms. Laser, I feel your pain. My 2 young adult children were so scarce on the campaign trail that some people didn't believe I had kids. Moving on, I am dismayed that the questions and the answers on this very important subject seem to be falling along party lines. This is an issue that I don't believe should be partisan. The separation of church and state is enshrined in our Constitution. Sadly, I often feel that my colleagues on the other side of the aisle only have respect for one of the amendments in the Bill of Rights and perhaps only part of that amendment. In any event, RFRA restored the use of strict scrutiny as the standard to be employed by the courts in reviewing actions that may infringe on the free exercise of religion. And for the non-lawyers in the room, strict scrutiny means that the government must have a compelling government interest before imposing a substantial burden on religious exercise or in allowing the intrusion of religion in government matters. So moving on to the Affordable Care Act, which is lawfully the law of this land and was lawfully passed. Section 2713 of the ACA requires individual and employer-provided health plans to cover certain key preventive services, including all forms of FDA-approved contraceptive methods, along with prenatal care, counseling for sexually transmitted infections, and screening for domestic violence. In implementing this requirement, the Obama administration provided a very narrow exemption to accommodate certain religious nonprofit employers, such as churches, that objected to contraception coverage. But in October of 2017, the current administration promulgated 2 interim final rules that allow virtually any employer or institution of higher education to circumvent the contraceptive coverage requirement entirely. And then we have Hobby Lobby versus Burwell, in which the plaintiffs, Hobby Lobby, a closely held for-profit corporation whose owners opposed contraception based on their religious beliefs, successfully argued that they should be exempted from the ACA and its regulations requiring coverage of contraceptive care. I stress to you, it is a corporation, not a 501c3 religious institution. So my first question, and just a show of the hands here, is there any one of you who disagrees that a corporation is separate and distinct from its individual owners, officers, and board of directors? Is there anyone that disagrees with that concept? Okay, seeing none. Is there anyone that disagrees that a business like Hobby Lobby aims to make a profit? You disagree with that, Mr. Sharp, so noted for the record. Do any of you, and specifically you, Mr. Sharp, do you know what is on Hobby Lobby's website?
I believe when you look at Hobby Lobby...
No, my question is, do you know what's on their website?
I don't know everything on their website, but I know their devout belief in God is.
Well, let me tell you what's on their website, because I looked at it. It includes a link to shop departments for crafts and hobbies. It has coupons for tabletop decor, summer toys, yarn, furniture, and wearable art. There is nothing on Hobby Lobby's website that promotes the owner's preferred religion. Despite the fact that you all agree that a corporation should be treated separately from the individual owners, and despite the fact that Hobby Lobby is in business to make money and its own website makes no reference to its owner's religious beliefs, we allow that company's owners to dictate their religious beliefs upon their employees by denying contraceptive coverage to those employees. So what does that mean for its employees who are of childbearing age? Any one of you care to answer that one? It means they can't get contraceptive coverage, right? Other than seeking alternative employment. It wasn't the federal government that was restricting Hobby Lobby's religious freedom. Hobby Lobby isn't even a 501c3 place of worship. It was really the owners of Hobby Lobby that were trying to avoid compliance with the ACA. So let me ask you this, Mr. Sharp. Would you allow a restaurant owner to forbid African Americans from sitting at the lunch counter to avoid desegregation laws?
No. RFRA has never been used that way, and if anyone attempted to, they would lose because the government has a compelling interest in eradicating discrimination based on race.
That's your opinion. Thank you. I yield back.
Thank you. Gentlelady's time has expired.